Thank you. I forget. I'll pull it in closer. Right. So, so what I'd like to do today is we have a lot of ground to cover. So I did put an agenda out on the table for those folks that don't have one. My hope is to be as Alexandrian as possible and kind of cut through the bulk of this agenda pretty quickly. Representative Gordon is going to be looking to maybe get us together in October to kind of look for the final disposition. So if we can, it'd be nice if we could kind of get through everything today. Um, so I'll start with a recap of the last meeting that we had. Basically, we had a lot of discussion about what is the caseload at the Human Rights Commission, and I think that we had come to a place where we were saying right now, as we're staffed with 5 investigators, cases in is equal to cases out. So we're in a place where the commission is operating in a steady state, but obviously the question remains that there's a big backlog and what's to be done about that. Next, we got into a discussion about the requirements of SB 296 and are the existing resources of the commission adequate to satisfy those requirements? And I think after some good discussion, we were pretty much in a place where we said, yes, indeed, the resources there, given the rate of removal, are adequate. We talked about the potential for the immediate removal to Superior Court if represented by counsel. The question was initially asked, what if we just did it across the board? The thinking was maybe just if there's representation by counsel. We talked about a recommendation memorandum that had come from the Association of Justice, and there was a timeline that went through that. And basically, the folks over at the Human Rights Commission were saying the probable cause standard, sorry, that is being discussed here is something that we are already kind of doing. So the question that arose out of that was just, could we kind of get some completion data before and after, the break-in date? When did we modify the standard, its application at the commission, and did we see any shift with respect to investigation time before and after? Because that would give us a feel, really, if doing that is going to do anything to kind of impact the timeline. We also talked about options for limiting the potential to amend claims, and then we kind of finished the day off with a penalty discussion. There were some recommendations that we could possibly look at penalties in the memorandum. So there was some concern, would that be penalties on an individual basis? What would that look like? Basically, we said, okay, we'll do some digging and we'll park that for the next meeting, which is today. So that's kind of just a recap of where we were in the last meeting. Yes, Representative Smith.
Thank you, Mr. Chair. Uh, I'm in awe of all the work that you've done, and I think it's incredible. But I have a couple of different reactions then, and I might be wrong, so please correct me. For example, I think we concluded that cases in and cases equal cases out was not applicable, since we were told that they took in 20 to 30 cases a month, and that they have roughly on average 4 hearings a year. That's number one. And related to that was in terms of the staffing, when we were told that the load was cut from 50 to 25 for each investigator, and we were curious about what happened to the remaining 25, we were told, well, they just weren't given to the investigator. So I don't think that indicates that the staffing is adequate. And so particularly on those two areas, I didn't see agreement. And then the third is the one we've kind of skirted around several times, and that is the difference in the length of time for any case as compared with what is required by statute and rules. And so, I think your summary is really optimistic, and I would like it to be absolutely accurate, but I'm not 100% sure that it is.
Well,
Thank you.
yeah, thank you, and you are correct. The active cases at the commission is about 20 to 25 per investigator, and so the surplus of cases that of the 50, that basically is what went into the backlog. So, but it was my understanding, and the director can correct me if I'm wrong, was my understanding based on the testimony that the accumulation was no longer accumulating, that the accumulation went back to when they had the two-member staff, but now it's about 200 plus cases in, 200 plus cases out, but the accumulation that had accumulated over the course of a decade, really, there's no impact being made on that. So basically, a case comes in, we're picking it up in the order that it was docketed, but everything else just has to go for a long time because there is nothing that's really being done to address the accumulation, which is why I think we're in a steady state, but nothing is being done to address the accumulation. That's why I think the significant backlog does remain, which is why I think it would be interesting to look to see, since we have modified the probable cause standard at the commission, what are we seeing with respect to the investigation time, and what are we seeing with respect to the accumulation, which is, that's I think what we have to whittle away at.
What do you mean that we've modified the probable cause? We haven't.
No, no. In, in the testimony last week, the memorandum that was presented was stating that there were recommendations in the memorandum that said we need to modify the probable cause standard to be less of a finding of fact, right? Which was what it had been in the past. So the director testified that currently they had modified that. It was my understanding, correct? Okay. Okay.
Do you see? Could you
Yeah.
go here, so because people are going to want to hear what you have to say. Thank you so much.
Good afternoon. Okay, so our internal case processing process was modified. The probable cause standard is still the same, but how we internally process our cases has been changed.
So yeah, so my understanding was, because the probable cause standard is statutory, but it was my understanding that, and maybe I misunderstood this from last week's testimony, that you had been applying a very aggressive, almost kind of super standard, and that you had kind of dialed that back a little bit to be more in line with the statute.
I understand. Okay.
All right.
I
And
understand what you're saying.
so the statutory language of the standard has not changed, but how you are approaching that statutory standard was changed to be more in line with the memo that was presented last week. And so you said, we're already actually doing that. And because we're doing that, the 1 year timeline, which was a timeline that was presented, is a timeline that we are meeting, was what I took away from the discussions that we had last week. Is that correct or incorrect?
I understand. Okay. So the memo that was given last week is separate from what we're doing.
Correct. That was
Okay.
recommendations on
Correct.
process.
Okay. Yes. And what had been done at the commission was there are different levels, um, different, not barriers, but different standards that the complainant must meet at every step. And what was previously happening was a very high standard in terms of report writing and investigation was being done prior to when it should have been applied. So, in looking at that and looking at how we can move the process along more efficiently, not faster in terms of negating rights or anything like that, but moving ourselves efficiently and paying attention to each standard that's supposed to be met at each step, we are in line with how we are supposed to be recognizing those standards at each step. I hope that answered your question.
Yeah, thank you for the clarification. Yes, Representative Smith.
Um, you said there are specific requirements for the complainant, not for the agency.
The complainant brings the charge, and they have to meet prima facie, which is that initial, at first glance, it's supposed to be here. I'm being docked wages, and it has nothing to do with discrimination. It doesn't go to the Human Rights Commission.
That would be the basic triage, the introductory triage, right?
You can call it that, sure. I mean, we're looking at the legal standard, so
Right.
it has to meet that legal standard.
Right.
Once it comes in the door and it is being investigated, then there's a back and forth. So the complainant has made the charge. The respondent responds as to whatever the complainant is saying that they don't agree with it because they did whatever that action was, and it was a non-discriminatory reason why they did those things. So they have an opportunity to respond. And then the complainant has an opportunity to say, well, no, that wasn't really what happened. It really happened this way. And so there's a back and forth until someone fails the test. And at that point in the investigation, the investigator is looking at all of the facts, all of the evidence that they have. They've done interviews with witnesses. They've taken written testimony. They've looked at files and all of those things. And then at a certain point, a determination of probable cause or no probable cause is made. And then the case moves forward from that point, depending on which door that charge is going into.
And how long does it take then to get from when the case comes in until probable cause?
When the case comes, the better question, actually, let me help you with that one. The better question is from the time that it's docketed to the time that it's assigned. I think, so for me, part of this process has been, there's been a lot of confusion as to the length of time the entire process takes. That the issue is not once it's assigned to probable cause, the issue is once it's docketed to assignment. That is what sits in pending, and that is what waits, and that is what has been building. Once it's assigned, then it moves through pretty reasonably. It depends on the case. It depends on what it is, but it moves through relatively quickly. And then the other metric, although I know SB 296 is specifically speaking about hearings, having a hearing or not having a hearing is not really the relevant question. What part of what we do, hearings are a part of our process, but the majority of our cases settle. So the settlement is the person, is the individual being made whole at some point, some sort of way.
Well, that's, I said probable cause. I didn't say hearing for that reason. Oh, I'm sorry. May I follow up? Is that okay? Thank you. But for someone who believes that they have been aggrieved and believe that the appropriate place for them to go, or the only place they're legally allowed to go, is to your agency, the critical time is from the moment that they submit the complaint until there's probable cause and things can move on. It is not the period from when they complain until it's assigned is your issue. It's not the complainant's issue. I mean, and so if meanwhile they're in a difficult situation, that time counts. Do you have a problem? If I could, just the last thing, and then I won't monopolize that problem. Do you find patterns in when you get, you say you average 20, 25, something like that a month, have there been any ups or downs over the course of a year or two? For example, have you been getting complaints related to the issue of divisive concepts?
There's a lot to unpack there.
I always
Um,
make it complicated on purpose, sorry.
I guess the question would be, so I would like to respectfully push back on the timing. The whole timing would be an issue, and it's specifically an issue for us for sure that someone is having to wait. So the important time, I personally feel as the executive director, that's really relevant to us moving things along quickly for people is the time that a charge will wait from the moment it's docketed to the time that it's assigned, because once it's assigned, it moves along pretty quickly. I mean, obviously there's back and forth. Sometimes people ask for extensions, whether it's attorneys, whether it's individuals that are not represented that are asking for extensions. And we try to be very cognizant of allowing people to have extensions in taking with the process, especially people who are not represented. But having to sit and wait where nothing is effectively being done because there's not enough staff to just continue to move through that, whether it's requesting additional information, reminding people about mediation and a variety of things to either settle those cases or be able to continue to get information in, that is a problem. And that is a problem for the complainant because there's nothing that's being done, specifically because there's not enough staff to do it. So I think it is very important to include that into the conversation and to make sure it's clear that it's not just point A to point Z. It's a lot of the steps in between that are equally as important. And in terms of the information, the cases that we get in, we have a variety of cases that come in every month. And yes, there are ebbs and flows in terms of how many cases are docketed each month. But that's not really relevant to the number of cases that are assigned each month, specifically because we have cases that are pending. So it is very easy to make sure that people have a caseload of 20, 25, or it could be a little more. If someone leaves, then that individual who might have 25 cases will get more cases because someone else has left. One, one docketed charge.
So I actually think that the time from when it's assigned until the probable cause, that actually is an important time. And understanding that, because a lot of the reform work that you're talking about is happening in that area. And so when it comes to the issue of the backlog, you can address the backlog in just a couple of ways. Either A, you have to put in resources, additional resources so that you can address the cases to kind of work the backlog down. Or if you don't have those resources available, and you don't at this time, we talked about that in a little bit in the last meeting, you have to look at that process from the assignment until when you're done. Because when that happens, that's going to shorten the investigation time. It's going to free up people to allow them, I think, to get to the backlog with the resources that you have. And so that's why I think that it is an actual important bit of data to look at. So one of the things that we did talk about was with some of the changes that you made, and I misspoke about the probable cause, but with respect to your process and your documenting and all that stuff. So with respect to that, you had made some changes, you said. And since you have made those changes, one of the things that we want to kind of understand is, had that had a measurable impact on the time, the actual meat of the processing from when it's assigned until when you get a finding of probable cause. So one of the things we talked about is we had any data on that. Were you able to find anything with that regard?
I think I do have an answer to that. So,
Okay.
with respect to that specific question, we began our new procedures in February of this year,
Okay.
and we have increased the number of closures by 50. However, to look at that equation as we're continuing to move forward with the new process,
Yeah.
and we're going to close more,
Yeah.
there's still more coming in. So it's not a finite number. So that's where the
No.
issue comes in terms of resources.
And I understand. One of the things that we talked about last week was, okay, we're at steady state. So we pretty much have the amount of cases coming in equals the amount of cases going out, was kind of what I walked away with last week. So are you finding, so when you say 50 additional cases, because what was the backlog? It was something like 300 cases?
It's not quite that much, but close. I mean, it might be like 250.
Okay, so 250 cases. So the 50 cases that so you're able to process an additional 50 cases. Is that since February?
Over
So-
the course of this,
Yeah, hang on. Go ahead, Representative Paul.
Thank you, because for me, this is a very key question. You're saying, what I'm hearing is that the processes you implemented in February have increased your closure rate, which implies to me that you're actually starting to reduce your backlog. Is that accurate?
I mean, it's a yes and no. So
That's correct.
yes, with the number, but if cases continue to come in, then you're not necessarily reaching all of those. Do you understand? I mean, you'll get some for sure, but if you have 200 cases and there's nothing else coming in, and then every, I don't know, 6 months you close an additional 25 cases, definitely it's done, right? If each person is closing another, well, if each person, we have 5 staff members, each person closes 10 above what they were assigned, then that's going to be 50 cases. So you're hitting the backlog because nothing else is coming in and it goes away. But when you have more hands that are lifting the same or more, then it eradicates it. So I guess I don't understand
Okay,
what's
so-
not
so-
understood.
Yeah. So yeah, I would appreciate a yes or a no. That's all. With the new procedures, with the increased closure rate, is the absolute number of backlogged cases going down?
Somewhat.
That would be a yes. Thank you.
Thank you, Rep. Right, did you have a question, Representative Gordon?
Not at this moment. I do have some comments.
So-
With regard to, if we're just following up on what Representative Smith has said, then no, but when we get back to your agenda, I do.
Okay. So, no, but I just, thank you, Director Malachi, but again, it's an important question because one of the big concerns everybody has, maybe not as it relates to 296, but just is we do have the accumulation rate, and we talked a little bit about resources. And so understanding the impact of the procedural changes you made with respect to that backlog is critical. So it does sound like it's new. It's only been since February. We're only in the September timeframe. So we understand that year over year, things can change. The amount of people filing can go up one year or down the year after. But in general, you are processing more cases and starting to eat into that backlog. Yes?
Yes.
Okay. We had talked about the probable cause standard. And so I did have sent out an email with respect to the language on the current standard. So does anybody have any thoughts on that? It should be on page 2 of the agenda. So according to the statute, determination of probable cause means a determination made after investigation that there is sufficient evidence upon which a fact finder would form a reasonable belief that the respondent committed one or more unlawful practices. So, yeah.
Just one minor correction, you had a letter wrong in one of those words. Because you said a reasonable person would, when the standard is could.
Right. You're correct. I stand corrected.
So yeah, I have a thought.
Yes.
It's the same thought I had last week. The standard is so low that it seems like it would be pretty much be very easy to meet that standard.
Representative Gordon?
Yeah, I have a couple of thoughts. And just to start out, and I know this is our last meeting and should be our last meeting, but I was wondering if we should have heard from the chair of the commissioners or from the commissioners themselves as to their responsibilities and their duties, because don't they have some involvement in deciding how the commission should operate? And after we left the last meeting, and as I was driving home, I was thinking, shouldn't the chair of the commission be here explaining how the commission works and why it works the way it does? But that's another issue. The probable cause standard, I think, is the issue. I don't really, I understand, and Director Malachi does a great job, and she's explained, and she's very defensive of the process. But I think the process is the issue. So she's defending the process and basically saying the process works if only we had resources. Well, I don't think the process works. That's my opinion. And the process doesn't work properly because we are addressing the issue of probable cause. We're basically having an investigator decide the case before the commission ever hears it. In fact, decides the case because the commission isn't hearing any cases. It's only hearing 4 cases a year. So, and we have another email which we received, at least the committee members received. It indicates the Department of Labor, when they have complaints come in, they don't have an investigation of probable cause. They look at it, make a determination based upon the filings as to whether or not there's a sufficient basis to move forward, and then schedule a hearing. And it seems to me that there needs to be some alteration with regard to the probable cause process because, and yes, I understand there's a delay in appointing investigators, perhaps because we don't have enough investigators. But I also heard testimony earlier that when the investigator has it, these cases are lasting. The investigator may not get appointed for a year, but these cases aren't getting closed for 3 years. So something's happening in that process, and that's that determination of probable cause. I sit on another committee, the ethics committee, where basically we do our triage. A complaint comes in and we look and see if on the face it makes a reasonable claim. But once it makes a reasonable claim, we don't hire an investigator to look. What we do is we have both parties come in basically before the ethics committee, explain, and then we make a determination of probable cause and whether or not there's a sufficient basis to go forward with charges. And it seems to me that there ought to be some alteration in this probable cause process that's more reasonable and appropriate than having an investigator basically decide the case for you. it seems to me that right now, the process, as I understand it, is the investigator can't decide probable cause, but basically does a full investigation, makes a recommendation, and for the most part, my guess is the commissioner a commissioner rubber stamps it. Says, yep, you're right. And so it seems to me that the commissioners could be making that determination, and then making that determination at an earlier stage. Instead of defending the process, the one thing I haven't heard, and that's why I sort of would like to hear the commissioner here, have the commissioner here. The one thing I haven't heard is, we think our system is acceptable, that we think our system is properly serving the people of the state of New Hampshire. I'd like somebody from the commission to tell me they think it is adequately serving the people in the state of New Hampshire. And if they could do that, then I would be surprised. There needs to be some change, some modification to make this system work and serve our constituents. Those are my thoughts.
So, to follow up on that a little bit, oh, actually, Representative Di Lorenzo, you had a question?
Oh, yes. It's a question for Representative Gordon. Representative Gordon, you mentioned that practically the investigator is the one who's deciding whether the case has merit and goes forward when you feel it should be the commissioners. Is that correct?
Right now, it is the commissioners, only they're taking the recommendation of the investigator. So,
Right.
but my guess is that they're rubber stamping for the most part,
Okay. Well, thank you.
that
Thank you.
recommendation.
Thank you for your response. And I think that that's a big problem because I think that we want to see transparency between all of the moving parts of the Human Rights Commission. For instance, an investigator does his investigation, cut and dried, hands it over to the commission and let them make the decision instead of the investigator driving the bus. And I think it would be more fair and more clear. Thank you.
Thank you, Representative Di Lorenzo. So, Representative Gordon, just, so it's my understanding then that if you look at the legal language in the probable cause, you're saying actually that's adequate. It's more just on the process side. And
Probable cause is it should be a very low standard. Okay. The probable cause, the New Hampshire Supreme Court said probable cause is less than more likely than not, and more than a reasonable suspicion. That it has case law that says that. And so it's a very low standard. And that's the standard to move forward to adjudication. But what's happening is you have an investigator, from what I can see, who's basically going out there, doing this full investigation, and coming back and saying, hey, this case, this is going to be the outcome of the case, basically. And then based upon that, the parties settle. But it seems to me that it should be, probable cause should be the beginning of a process, as opposed to, as it is right now, the end of the process. Because what is happening is they're going through this whole process of probable cause, and then, as the director just said, most people are settling. And the reason they're settling is because you basically decided the case.
so I just want to kind of follow up, with a question back for you, and then maybe a follow-up question for the director. So, with obviously you've been a judge and you've sat on the ethics committee. We have the research from Kristen Grant. So, in those labor board ethics committee, when it comes to probable cause, is there an investigative process in those relative bodies, and what's its nature relative. I mean, we kind of talked about the investigation that goes on at the Human Rights Commission. Comparatively speaking, where do you see it in these other bodies?
In most cases, it's not, in most bodies, it's not an investigator that's going out and investigating. It's the parties that are responsible for showing the evidence that's needed to meet probable cause. And so, for example, if you have a criminal case, a felony case, you have to have probable cause in order for somebody to go to a trial. That probable cause in a felony case is supposed to be made within 20 days. It was, at least as far as felonies first is concerned, or felonies in the circuit court, within 20 days. And it's up to the police to say, you know, this is the evidence that we have. It's up for the defendant to say that's not true. And you make that determination. And once you make the determination, a quick determination, then you schedule it for trial. And then the parties do whatever research they need to do to determine.
Yeah, thank you, Representative Gordon. Director Malachi, the Human Rights Commission is kind of, it's a bit of a unique entity, and it does have, so maybe you could kind of walk us through some of the history. Why would the Human Rights Commission have such a departure from these other bodies with respect to the nature of the investigation?
Thank you. So that would actually be a question for the legislature who created us in 1965. But part of the confusion, I think, there's a lot of mishing around with a lot of different things. We are not criminal, and so a lot of the explanations that have been given specifically deal with criminal cases, which are very different from administrative law cases. And I think that's part of the problem with the confusion as to what we're discussing. What's also being missed is that the commission we are police officers, we are a district attorney, we are a defense attorney to some degree if there's a hearing and we have to represent the complainant. We do a variety of things. We're the judge, we have a jury, we are all of those elements all put together in one. And so the problem is when we're discussing probable cause in a criminal case, as the judge gets it and the people come before the judge, him or her, what has eloquently been missed is the nuance. All of the investigation, all of the information gathering, all of the determination of can we go forward, can we have a search warrant, can we gather this information, that's done before it gets to the judge. We do all of that. So that is a part of our process. It's not that everything walks into the door nice and neat. When you come into a courtroom, all of the legwork, all of the research, all of the investigation, all of the talking to witnesses and looking under bushes and finding pieces of paper and books and all of those things, all that's been done. So when the judge gets it in a criminal case, that work has been done. When something walks into our door, it's as if someone walked into the police department and said, someone stole my car. Now someone has to be assigned to take the intake of who you are, what happened to your car, and gather that information. And then it goes through the process. We do all of those processes. We are not simply a court where something is complete and walks into us, and then we make a determination, and then whatever happens after that happens. We are all of those processes from soup to nuts consistently.
Thank you, Director. So, and I take your point with respect to the difference between the Human Rights Commission and, say, a criminal court. I did ask Kristen to give us the difference between the Human Rights Commission and the Labor Department, which I thought were kind of similar, which is why I kind of asked her to kind of look at that. And in that case, if you just go to the second page of the agenda, a hearing in the Department of Labor, on the other hand, does not require showing of probable cause. So it looks like in that situation, it just goes forward. So again, I'm just trying to understand. There's very, very different approaches here, and why if you have any understanding of why there is a departure between, say, the process that the labor folks would use and the process that you would use. Oh.
I'm not familiar with how the labor department is set up. I mean, I know they have significantly more investigators than we do, so that
Okay.
makes a huge difference. I'm not familiar with their process, so I can't speak to that. I don't know why they don't do an investigation first or they do it later. I don't know.
You had your hand up in the back? Yeah. Sure, you could sit over there. We did, it's a work session, so you could.
Got a lot of points I want to address, but I'm going to try and keep it simple so we can move through it. Yes, thank you, Representative Smith. Why does the HRC have such departure from the investigation that other agencies do? I think that's because of the law that the HRC has been designed to administer. There's that whole McDonnell-Douglas burden shifting framework for employment law, which basically says, employee, you have to present some evidence of your prima facie case. Employer, did you have a legitimate non-discriminatory business reason for doing the action? And then the employee gets to say, well, actually, their reason is a bunch of, yes, a bunch of hooey. It's not right, and here's what actually happened. So I think the HRC does have to have a little bit of a different investigation than other agencies, but I agree the process can be changed, it can be streamlined and made better. I think that was the point I wanted to jump up for right now. I can hold off on my other points for now. Yes.
Well, no, just as a quick follow-up. So, so they have that standard over at the Labor Department. Do you have any knowledge as to, because I wasn't around when the law was written in 1965, so as to why they would have the different standard at the Human Rights Commission?
My knowledge, and I'm going to invite my colleague Megan Douglas to jump up and correct me if she has a different view, but my knowledge of that is when this law was implemented, we wanted a gatekeeper to keep these cases from flooding the court system. And so we wanted the HRC to basically operate at the gate and cut off any frivolous claims. You know, for example, if somebody says, my employer said that I have to tuck in my shirt to come to work, so he's discriminating against me because I'm a woman. Something like that would be a clearly frivolous claim. And that's the type of stuff that the HRC is supposed to weed out before it ever makes it to the courts so that we don't clog up the court system. And I think that's how that got started in the first place.
Okay.
Unless there's someone here from labor that could speak specifically to how labor does their process, I don't think we have an answer. I mean, I know what we do generally reflects how the EEOC, which is the federal agency, does their cases. We generally reflect their process. So I can only assume, dangerous words, but when the HRC was created, that it would reflect what was statutory for the federal government. That would be my guess if I had to venture a guess.
All right. So I think I think we're in a place right now where we talked about the probable cause standard. We're comfortable with the language. We're saying, are there some things maybe that we want to do around process? So we'll go on to that bit of the agenda next. So, Representative Smith.
Thank you very much. When you were able to go and meet with the staff, which I think you did at the beginning of September, if I recall, did you have an opportunity to read one of the HRC reports to see what it was like?
No, I did not.
Has anyone on the committee ever seen one? I'm just curious about this whole question of the detail that that a competent, responsible investigator feels is necessary to go into that report, which seems to take a lot of time. And I was just curious if anybody had seen such a thing.
Oh, Attorney Douglas has one?
Thanks, Marissa.
And I just want to say, representatives, Megan and I didn't get a chance to connect before this meeting, so we're happy to have copies made and sent electronically to you all so that this isn't the only copy.
Yeah, so I thought it would be helpful for you all to have a visual of what the investigation looks like as finally documented in the probable cause or no probable cause determination report. The problem in disseminating it is that it's confidential. In this case, the plaintiff wanted to stay at the commission precisely because it was a confidential process. She didn't want to go to court. And so I took some time to redact the information, and it took quite a while because the report is lengthy. But what, in my view, the report shows, I'll tell you, it's 1, 2, 3, 4, 5, 6, 7. I could have counted the page numbers, huh? 9 single-spaced pages. It looks sort of like a summary judgment decision. It looks like the investigator here did this over a course of years. And in this case, despite the fact that the plaintiff had 2, 3 witnesses corroborating her theory of the case, no probable cause was found. And so I thought it would be helpful to you. Also, this investigation shows that the investigator was not able to contact an important witness until he separated from employment for 19 months. So it was a year and a half that he was out of the job where this lady worked. And consequently, he didn't remember her at all, or at least he said he didn't. And he wasn't able to say anything that was helpful to her, even though years prior she had identified him as an important witness. So, again, no probable cause was found. I'm happy to send this around the table. I think I did a fairly good job of redacting. I don't know if that means that necessarily it's publicly accessible, though, if you look at it. What does everybody think about that? Huh? Yeah. Okay. Well, I guess you can look at it from afar. It does exist. I mean, I guess you'll have to accept my representations as to what's in here. I can tell you a little bit about the case if that would help. It's stamped here. I received it January 22nd, my birthday, in 2020. And the complainant was fired. She filed her charge March 17th, 2017. Yeah.
I just want to respond to Representative Smith's question a little bit about what do these reports look like. One thing Megan said was that even though the plaintiff in this case had corroborating witnesses, no probable cause was found. That's really important because the plaintiff identifying corroborating witnesses probably occurred at that third stage after the employer's already given their reason and the plaintiff says, no, that's a bunch of hooey. Here are my witnesses. Here's why these are important. If the probable cause standard as written had been correctly applied, the plaintiff should have had probable cause. Because like Representative Gordon said, what's happening is that they're deciding the merits of the case, and that's not what's supposed to be done. They're just supposed to be saying, have you given me something to believe that the type of discrimination you say happened actually did? And if you've given me something, even if I don't necessarily believe it, if some reasonable person could, that's good enough, check the box, move on. And this is so detailed, Representative Smith, in analyzing every potential fact in the case that it's going above and beyond what's required. Say I have gender discrimination at work, and I've got 5 examples of how that's happening to me. If the probable cause standard is applied correctly, I only have to give the HRC 1 before they can say, okay, you get to move to the next step. Because I just have to give them some credible evidence that a reasonable person could believe. That's all I had for now.
Representative Gordon.
In effect, that's an adjudication of the claim.
This, yes. Yes, Representative.
And what happened to this plaintiff is that she didn't, because no probable cause was found, she has no relief at all under RSA 354A. She can't go to Superior Court. She can't bring a 354A claim. It's done. She could appeal the no probable cause decision, which I've done once, and that case has been, it was remanded to the commission, and it's now going on 6 years of adjudication.
Question
Representative Di
question.
Lorenzo.
for Megan. Hi,
Yes.
Megan. So in that particular case you were speaking of where they found no probable cause and, the case was like just dropped, right? Is there an option or an avenue to go before the EEOC on a case?
No, because the charge is dually filed with the Human Rights Commission and the EEOC. They have a work sharing agreement so that one will investigate claims under both Title VII and RSA 354A. Now, this employee could have brought claims in court under Title VII. This is a gender discrimination case. She was a female boss who cursed in the workplace, and it was decided that she broke the ethical code of the company. Meanwhile, there was a comparator employee, a male, who was behaving pretty badly on the regular, and nothing happened to him. And that was the basis of her claim. She could have brought Title VII claims in court, but she wanted to avail of the confidential process. The industry in which she worked was very, I don't know what the word is, insular. I mean, it was very close. Sorry? Yes. And actually, after she was let go from this job, she got a new job in another, employer in the same biz, and mysteriously that job just evaporated. It was offered her, and then right when she was about to start, it was taken away. And there were facts suggesting that there was a meeting held between the former employer and the new employer. So there you go. That's why she wanted to stay at the commission, and she was done there.
Thank you. So I guess though, I don't know how to proceed at this point with, obviously, we said that we think that the standard itself, the statutory language of the standard is good. So this now just comes down to the application. In this particular case, we're going forward with a full adjudication, it sounds like. So do we look at bringing in statutory language that really tightens up that process, or I think that's a big nut to pull off.
Representative McLean,
Yes.
if I could. I actually have an idea about that, and I don't think we need to bring in statutory language. I think we could do it with the rules of the agency, which have been expired now for what, 5-ish years?
The rules are,
Several years.
well, yeah, the
We
first
could
two
amend them.
sections of the rules are expired.
But we could amend those rules to address these issues that we're discussing. And our memo that we set forth with the 1-year timeline, I think would address most of these issues. And this morning I've thought of new ideas to streamline that even more and make it even better, cut down the investigation time. But that would allow, in my view, the HRC to allocate their resources such that they could simultaneously investigate new cases coming in and address the backlog in more meaningful numbers. Because we'd be decreasing their duties per investigator. They'd have less things on their plate than the way they've been doing things. And for example, this memo that you all should have, we put first quarter, investigator has initial, this is at the bottom, number 3, investigator has initial discussion with complainant to determine what documents and other evidence are necessary to the case. Instead of doing that, we could cut that step and we could put the Form 5, the form that complainants fill out their charge of discrimination on, we could add a second page to the Form 5 that has a checklist of documents that the complainant has to identify at the outset for the commission. I believe these documents exist that are relevant and will show you that I've met my probable cause standard. Please go get them, investigator. And all the complainant has to do is check the box of the types of documents that might exist. And then at the investigation phase, we can, and this would take some time, but a group of employment lawyers, NELA and NHAJ, could work together to devise checklists by the type of claim, such that when the investigator gets into the investigation, all they have to do is look at this checkbox list and say, have they offered me some evidence that they're disabled? Check the box, yes. Have they offered me some evidence that they asked for accommodation? Yes. Have they offered me some evidence that they were terminated because they asked for accommodation? Yes. If so, proceed to commissioners. Off their plate quickly.
So, but pardon my ignorance, since that's being taken up potentially in the rules, which is saying have been expired for quite some time. And this is just me being ignorant. What would the mechanism for that be? And would we, as a legislature, have a role in that? Or what is the mechanism by which that comes to pass?
I believe the rules are amended through GELCAR. And my understanding, which may not be correct, my understanding is that the HRC itself is responsible for amending those rules and submitting them to GELCAR under the APA. And I see nodding heads, so I'm thinking I'm maybe right on this one. But I would be willing, and I can't speak for other employment lawyers except for this one, but we'd be willing to help come up with some rules so that the agency doesn't have to do this on their own. We know they have other work to do, and setting time and people aside to come up with new rules is difficult. I'm sure we can gather up some other employment lawyers as well. And I'd also be happy to have committee input on, our draft, the employment lawyers' drafts of the rules, see what you guys think about those, and then maybe we work with the HRC directly to get those passed through GELCAR. Just an idea. I'm not sure if that would actually work, but.
Yes, Representative Wolf.
Yeah, and what we would do is recommend there be a commission to rewrite the rules. And
A special commission? Okay.
so we're an interim study. We have a bill, and we say we're going to study that, and we'll figure out what to recommend. Well, what we can recommend might be to have a commission to rewrite the rules under which the HRC is operating, not necessarily, accepting the statute where it is, but just looking at rewriting how the commission is actually operating. So that's one thing we can do from here.
I think that would be great. And I also know that from my memo, I had written in here that we need some type of mechanism for enforcement or penalty. And I know I didn't provide any suggestions about how we might do that. We've come up with some ideas. RSA 189.13 and 189.31 are statutes governing the dismissal of teachers. And essentially what it says is if a teacher does certain bad things, they can be dismissed, and the superintendent gets to refer that teacher for dismissal to the school board, who then holds a little hearing. It's more like a meeting, but they call it a hearing. And the school board makes a determination, and the teacher might have to hit the road. We could do something very similar here, where executive director acts as superintendent and the commissioners act as the school board. So if we outline these new rules and we come up with a 1 year or less process by which HRC can get a case done from start to finish, and we see investigators, or not we, if the executive director sees investigators who are not doing that, who are not satisfactorily completing their job duties, the executive director shall refer that investigator to the commissioners for review. The commissioners will sit with the investigator. Is there good cause for the reason you're not performing your duties? Is it a delay of someone else? Tell me what happened. And the commissioners get to decide whether or not the investigator continues at the commission. I think that's something we could write right into the rules as well.
I think it might work because it's borrowing from another public employee process, right? And it would give the executive director sufficient control, administrative authority.
Yes, Representative Smith.
Thank you. You've all been terrific. You've given us lots of help, and I think all of us in this room want to see this agency work. I personally am not thrilled with what you just suggested, because the problem is that the investigators are doing now what they are expected to do, and what the director holds them to do in terms of how long the cases go and whatever. So I don't think that solves anything. I think we have to solve the underlying issue, which is the fact that the investigators working hard and doing due diligence have in fact ended up acting as, almost in the words of the director, of being judge and jury. And it seems to me that we don't have to form a commission, which can go on forever and ever. We don't have to do any of those things. What we have to do is say very clearly that the language should clarify the fact that in order to get to probable cause, it is just to establish certain basic facts, and that is probable cause. Probable cause is not the trial. And that can be done, and we can, Jelcar, meanwhile, should be asking why 5 years have passed and there hasn't been a review of the rules. And all of that we can do in recommendations, and that would put, when the new Jelcar is formed after the election, we can be right there and related to the other efforts that we're working on, and move this along. I think that everybody in the commission is acting in good faith. They're doing what they think they're expected to do, and we just disagree with what they're expected to do. They're not expected, the investigator is not expected to conduct what I'm calling a trial, just in shorthand. I think we all know what I mean. And that should make Ms. Malachi's work a heck of a lot easier, it seems to me, and we would be helping her address what seems to be one of her very real concerns, which is the backlog.
If I may just respond briefly.
Yes, please.
I agree with you, Representative Smith, that I think the people there are working in good faith, and I don't want to agencies are made of people, and people are subject to human error even when they're doing their best job and putting their best foot forward. So if we were going to do some type of change to the process and the rules, I would propose that we first revise the process, like we've been talking about, a 1-year timeline, checklists, etc. And then we delay we give the investigators time to adjust to these new workplace expectations. And then at some point, maybe we consider implementing the process of, if executive director sees people failing to satisfactorily complete their job duties, she may consider referring them to the commissioners.
State employees, there's a problem, they have to go through the process. We don't need to have special.
Okay.
We don't need to put special additional pressure on the director. There's enough pressure on her to try to do the right thing. I mean, ideally, as painful as this process has been for all of us, and it has been very painful, I know for me, and I think for everybody else, ideally, we can come out of this with the debtor able to meet the needs of the citizens of the state who rely on the Human Rights Commission, and make it possible for the staff to do their job, and their job isn't to, in effect, have 2 trials.
Yeah. So I think, yeah, I think, and I've never worked in state government, but I'm certain that, like any other agency, even in the private sector, that, Director Malachi holds reviews with her people, and if they're not performing, then, there's accountability there. But what I was thinking about, and I was giving it a lot of thought, especially in light of, we got a memo from the committee researcher just looking at other agencies, and it doesn't seem to be a lot of, penalizing individuals. I was thinking something, I just would want to get your thoughts along the lines of, in the rules process, really codifying if there's non-cooperation with the commission. Like when I was in there and I was speaking with folks, they say, in the past, we would ask for this, and there might be people dragging their feet or things of this nature. And sometimes when we were really overwhelmed, we would let that go because we were overwhelmed, and actually it gave us a little bit of a breather. But I was thinking, maybe if you're going to revisit the rules, from a penalty perspective, it might just be if you're non-complying or non-cooperating, that's ground, for immediate loss of your case or something like that. I was thinking something along those lines. What are your thoughts on that?
I think that certainly if a respondent isn't compliant with an investigator's request for information, for example,
Yep.
then no probable cause should be found. I mean, sorry, probable cause should be found.
Right.
My mistake. I think what Sam and I were trying to brainstorm was, well, what happens if we have a rule in the statute that says investigations shall be done in 2 years, and they're just not, and they're not, and they're not for reasons that aren't sound, right? We thought you all had questions about accountability and enforcing whatever we put in 354A, and so we tried to come up with something that held people accountable, but also, gave people process and rested most of the authority in the executive director for accountability. That's why we looked to the teacher statute.
Okay.
I can't think of any situation where an agency as a body is punished for not doing its job. I couldn't think of any analogous situation, so that's why we looked to the teacher statute too.
And I would just add on to that, if we clarify the standard alone, I don't think that's going to be enough to move these cases through quickly enough to get a significant reduction in the backlog.
Yeah.
I think they have a very hard job over there, and I think we can make it work with the resources they've got if we just give them some tools. It's a complex area of the law, but luckily we have a bunch of employment lawyers practicing this area regularly who can give them tools to simplify their job. I wish that I had a checklist of elements of the law at my fingertips every single day. That'd be awesome because it'd make my job simpler. We could do that for them.
You know, I do agree that further clarifying the probable cause language, you know, based on some of the discussion today and the comments, you know, from Representative Gordon, we're probably in a good place with respect to that language. It's I think it's just a question of application. But I would. Oh, did you have a question? Okay, so, but I did want to give the director, we've been talking a lot about the fact that we haven't had rules in a while, and we'd like to go back and revisit the rules and things like that. So I would like just to give you the opportunity to give your thoughts on that. Do you think that's a good way to go? Why is it, just, yeah, just, what are your thoughts with respect to basically moving through the rules process in this area?
Thank you. So much to unpack. We do need to go through jail car. Period, full stop. I don't agree with the majority of what complainants bar shared. You know, we could, as soon as something comes in and it meets prima facie, we could just mark it probable cause and move on, whether the respondent responds or not. I mean, that would certainly be easier and we would move things through. I don't think that's what any of us want because then that's not giving the respondent an opportunity to respond. So part of the process is that there's checks and balances along the way. And based on the suggestions, it's removing some of those checks and balances. I think the Attorney General's office is smart enough to assist us with any check sheets that we might need. I don't think we need their assistance in doing that. I appreciate the offer. We do have internal things, but I think part of it goes back to there's still a lack of clear understanding as to what we do. These sessions, whether it's a hearing or these meetings, are very specific questions and very pointed questions, which is great. But unless you come and look at a charge as it's walking in and take some time with us to understand our process, you're still missing so much of the nuance. And the report that was shared with you was from 2020, which was part of the problem. We don't do reports like that anymore. But if you have complainants bar that is slowing down the process, if we're going to assess penalties, then everybody gets a penalty, not just one side. So, I mean, there's a lot there. But I think the rules are, there's some areas of the rules that we would like to tighten. There's some things that need explanations. There's some things that we do that maybe we shouldn't do anymore. Pro hoc vice, long conversation, but putting that on the record, maybe we don't need to do those. And then that removes some opportunities for certain attorneys outside of the state to practice before us. Maybe there's a different process that doesn't involve us that should take place. So that's something important. But I think the agency itself, with the guidance of the Attorney General's office, can manage to make it through jail car, looking at our rules, having our commissioners approve them, and then that whole process is public anyway. So if others want to make comments and suggestions, they're welcome to do so. It doesn't mean that we need to adopt them, but they're welcome to chime in.
Representative DiLorenzo?
Thank you, Mr. Chair. Thank you, Ms. Malachi. Thank you for all of your hard work. So I was wondering, is there a national organization of professionals, like a professional organization for state anti-discrimination agencies that you might be a member of, or different states are members of?
Other than the EEOC, because that's who we practice with, we usually are in a work sharing agreement. So other than that, that's all that I'm aware of.
I thought it might be helpful if there were a national association of, folks who work for anti-discrimination state agencies. Because that's where
right.
a lot of, practices get polished, and agencies, I guess I would say they advocate for themselves, and learn new practices, and there's always training and stuff. So,
Yes. Well, the EEOC's process is a bit different.
Mhm.
And they do move it a lot faster because what they do is they set priorities every year. So let's say immigrant workers, minority workers, and women are their 2023 priorities. If your case isn't really rock solid, you are dismissed. There is no investigation. They give you a right to sue and you're out the door. You're done. So that would help us as well if we adopted what the EEOC did, but the commission, based on how it's created, has elected not to do that and to provide full investigation. That's relative to whoever's asking the question, but to provide an investigation. So everything that walks in the door is going to get something, someone is really looking at it, not just, well, this doesn't quite meet our criteria, or this one isn't very strong. There could be something there, but it makes prima facie, but that's it. And then it gets dismissed and you get a right to sue.
Follow up. So does do your workers at your agency attend any HUD trainings on fair housing, that type of thing?
So there is a HUD training annually, and the EEOC participates in that. It's a civil rights training, and they do attend that every year. I have made sure there's money in my budget for them to attend that. And if there are any trainings that are online, at this point, because of COVID, things are a lot more accessible. Whether the EEOC is offering it, we always take those trainings, or one of the other sister agencies in New England that offer something, the staff will take those, or if there are other trainings that are approved, they will take those as well.
That's great to hear. Thank you.
Representative Smith?
Next question. You referred to the complainant bar, and the earlier witnesses referred to the employment bar. So in that case, I don't know if I should ask you or them whether all the attorneys in the employment bar are there to represent the complainants rather than employers.
You know, there are attorneys that represent both sides. So like the attorneys we have here, they customarily they represent an individual that's bringing a charge. And then there are other attorneys that will represent the company that is responding
Right.
to the charge.
But so the group well, let me ask you, so when you gave us suggestions, are the suggestions only from those people who represent the complainants? Thank you.
Representative Gordon?
Director Ed, it started off the last session or the session before that, just saying that it would seem to me that if I were a litigant, that I would have a reasonable expectation that my case would be resolved in a fairly timely manner, maybe in a year. That might not be consistent with the current statute. But it seems to me that if I were to go to court, I would expect my case, or hope my case, would be resolved within a year. And from what you've just said, and that's not happening now, and we're not doing it within 2 years, it's taking longer than that. So, and from what you just said, we're talking about making changes in the rules in order to facilitate change, to maybe speed up the process, to make it work and perhaps get it down to a year. So, but you've indicated that you don't think that there's a need. I don't want to quote you, but basically what you've said is you don't see a need for major changes in the rules. There are some changes that need to be made, but no major changes in the way you go about doing things in the rules. So, other than adding resources, which is what you've said in the past, is you just need more investigators, more people. Other than adding resources, how would you go about bringing that time frame down to a year?
Thank you. And actually time in court is 2.5 years. So longer. Um, part of changing that time frame is doing the internal changes that we've already done. Okay. And then continuing to look at other areas that could make things move faster. So is it, we're working right now on creating a list, actually a checklist, but a list that goes to the respondent in their notice letter to say, so we already tell them to hold on to all the information, but reminding them that you can send in on both sides. If there's information that's important to your charge, send it in. You don't need to wait until something is assigned. Part of it is staff turnover. I mean, I'm losing someone now to the federal government. So some people, they get in, you're training them, and then they don't work out, so they're terminated. Some people get in, they're doing a great job, and they move on to make more money, whether it's within the state or outside of the state. And when that happens, because we have 5 investigators, when you lose one person, that's a fifth of your workforce, which means the people who are already doing what they're doing are taking on those cases that were assigned because someone's already made reached out. So they're taking those cases on, which means what's waits a little longer until those cases continue forward. So that's the other part as to why it's important to have additional staff, because if someone leaves or if someone's terminated, they leave on, hey, I found a better job, that's great, or they are not doing a good job and they're terminated, you don't have such a seismic shift in your workforce. And something that hasn't been really discussed, I don't have an administrator in my office right now, and I haven't since 2020. One of my investigators, whose job it is to investigate, is doing administrative administrative case work as well as her investigations. So that's all a part of it. It is very nuanced, and that is why not fully understanding what we do, the limitations that we're facing, and how we're doing it is a challenge. And because the staff was cut, then that was in 2011. That was why the time frame, I believe, was increased to 2 years. If you want to make it 1 year in the statute, that's fine. But I need more staff in order to do it, because if I only have the 5, or if I end up with 4 and one person leaves, there is no way to make that work when you don't have the individuals that are responsible for their key things. So along with administrative, one investigator doing administrative work, I do it as well, and everything else that is on my plate to do. So to answer your question more fully, we will continue to look at what policies and procedures internally we can change. And that is why there is such an amazing relationship with the AG's office to help us look at this, to tweak. And then I'm constantly talking to the investigators, and we've come up with toolkits and things to send out to unrepresented folks so they can do some of the charges on their own. It still has to be looked at, but then they can do some of that writing on their own, which relieves some of one piece for intake, but it doesn't change the volume of things that are coming in and the phone calls and the constant communication that needs to take place.
Any other thoughts or comments? Yes, Representative Smith?
Thank you. When you submitted your request to the governor, did you request additional staff?
I did.
Good for you. Thank you.
I requested 4 investigators and a training person so that we can actually make some headway in what's happening in the state. And I have a paralegal, and I requested to make that person full-time, and to also have my admin refunded or funded again. I'm not sure the correct term for that, as well as having the part-time person in intake, having the funds put back for that. Then we would be fully staffed, and I feel like we could really make a big dent in what's going on, as well as training.
So I think we're at a place right now where we kind of went through the meat of the, oh, yes, you had a comment? Yes.
One thing I just want to clarify, and that's probably an error on my part, because I get a little excited, I talk quickly, I skip over things. I am not advocating that we deprive the respondents a chance to respond, because that would actually be contrary to what the law requires. I am just advocating that we simplify the process of employee makes initial claims, employer responds, employee then responds to employer's response. Second point I would make is that I know Director Malachi feels that the HRC with the Attorney General's assistance and working with JELCAR is sufficient to get these rules passed. Respectfully, I would say that that's been the situation for five-ish, however many years the rules have been expired. And clearly that's not working. So I think some additional, and I agree with Director Malachi, I think that they probably do need additional resources. My proposal is offering them free resources. Nobody has to pay for my time to help them come up with rules. And I would not profess to know the ins and outs of what they do on a daily basis. So I would want to work with Director Malachi and anyone else from the Human Rights Commission who is willing to help us get rules passed. So I'm not there every day. I don't know what goes on inside those walls. But I do know the law that I practice in, and I and some others, and we can gather a bigger group if we ever get to that point, are happy to pitch in our time and resources free of charge to get things moving. I respect that Director Malachi has taken the initiative to implement internal processes to improve things. I think that's really hard to do when you are under-resourced and you're struggling just to keep up with the day-to-day. But if internal measures were enough, I don't think we'd be here right now. And that's not to be dismissive to Director Malachi. I think she's doing a great job. It's just that I think she's got a lot on her plate and maybe some help would be nice. That's all I have.
Question?
Representative Di Lorenzo?
Sure. Well, thank you for your presentation. And as you were speaking, I was wondering if there are resources that may be able to help the Human Rights Commission workers. And that could be maybe a special effort by the Bar Association, the New Hampshire Bar Association, because I know that, like in Massachusetts, they have the Legal Advocacy and Resource Center, which I trained in 100,000 years ago. And then the law clinics at the law school, maybe some help there. So I think we have to be a little bit creative. Maybe I see Annie's face saying, but, I'm sorry? To help with the intake or caseload or whatever they can do. Something to think about. Thank you.
All right. Anybody else? Okay. Oh, Representative Gordon.
Just a comment, and that is, I think that some overture could be made to the governor's office as well in terms of making change in the department, because I'm sure he's as aware, or the governor is as aware of the issues as we are.
All right. So let's just kind of get into a little bit of the wrap up here. So as Director Malachi said, there's a lot to unpack. So, in terms of the path forward, we're going to have the executive session for the whole committee in October at some point. So I just kind of want to get some consensus as to where we want to go and what we want to bring forth to the broader committee. So does anybody, I have my thoughts, but I don't want to kind of start with them. So does anybody have any thoughts that they'd like to bring forward? Representative Di Lorenzo?
Oh, thank you, Mr. Chair. Well, I would like to work towards passing SB 296, make that the priority. And that's, with our committee. Okay.
Representative Wolper?
So unfortunately, passing SB 296 is not within our purview. The
Oh.
the best we could do is say we recommend it
Right,
be
absolutely.
reintroduced
That's what I mean.
and passed.
Okay.
Yeah.
And all that would do, as it's written, would be to remove the right of the respondent to remove after findings of probable cause, which I think would be a good thing. Don't get me wrong.
Mhm.
But I don't think it does anything to resolve the
Yeah.
situations that we're hearing about and the timeline of all of this, which is, I think, our greater concern. I think that's really why we're sitting here.
So, I mean, from my perspective, the reason that we wanted to interim study this was because we had concerns about the resources at the Human Rights Commission to be able to satisfy the requirements of 296. So I think actually pretty early on with respect to the work of the subcommittee, we came to an understanding that SB 296, its original language, is constitutional, and that 48 other states already do it, and that the Human Rights Commission does indeed have the resources to do that. So from that perspective, the core of SB 296 as we received it, I would be comfortable going to the committee as a whole and saying, yes, we recommend this for future legislation. It's constitutional. Other states do it. The resources are there. Boom. So from that perspective, I think we're okay. There may be, though, an opportunity, and, you know, part of our discussions have kind of unpacked some of the other things that are going on at the Human Rights Commission. There may be, though, an opportunity to add to that. Now, we do have the performance audit where we're going to hopefully go before the LPAOC and ask for something, and they'll kind of look to see where does that kind of dovetail in with the other priorities of the state. They may decide to go forward. They may not decide to go forward. But the other area where I do think that we had broad agreement was on the fact that it's worth going back and revisiting the rules, especially in light of the fact that they've been expired, I think it was said, for 5 years. And so, you know, while and I don't know what would constitute that rulemaking committee from JELCAR. I would assume you would have folks from the respondent side, the claimant side. You would have folks from the HRC or not. So you have some, Representative Smith.
Thank you. I think you're making a good point, that we can begin by saying the bill, having reviewed the bill as it came to us, the bill is fine as far as it goes. However, there are 3 other areas that we think must be looked into. One, that we strongly urge JELCAR and the commission to work together to come up with new rules based on all the knowledge that we've had. So that's probably number 3, but I said it first so I don't forget it. Okay. Secondly, that we strongly urge the performance audit group to look into not the financial, but the operational, the performance piece of. And third, that we clarify either through rules or, if necessary, through statute, exactly what is meant by I'm having a blank. By probable cause, thank you. And that we believe that our research has shown us that probable cause, as it is interpreted currently by the commission, goes further than our standard understanding of probable cause, and probable cause should very clearly be just the initial judgment, yeah, that yes, which I use the word triage, but maybe that's not the right word, that yes, this is something worth pursuing. And that, and I think we have to mention that and hope that when, could be us, we could present to OLS a new bill. Everybody here except Ned could present a new bill that that includes in it the language that we think is fine that we got from the Senate, plus a clarification of the interpretation of probable cause. The other two things are already legislative, and that would be Joe Carr and performance audit.
So, yeah, so
Does that make sense to people?
first of all, I agree.
The only issue that I have with the probable cause definition, it's in the statute. It says it makes the determination the standard that's applied is correct, but then it says that the standard after investigation. And I think that after investigation is the issue, because it seems to me that you could find probable cause after you do the three-step process and of the initial complaint submission, the employer's response, and then the complainant's subsequent response. You could make a probable cause without necessarily having a full investigation.
Yeah, so just 1 second, Representative Walpole. I just had a question, then I'll go right to you. So you're saying basically to leave that part open? Maybe have an investigation, maybe not, but basically provide latitude.
Well, I think the way it's being interpreted right now by the division, you have to have a full investigation in order to find probable cause.
Okay.
And I think that's the issue, is I don't think you need a full investigation to have to find probable cause. And what you're doing is basically adjudicating the whole case, having the investigator adjudicate the case, basically act as a judge, adjudicate the case, and then give it to a commissioner to make a finding of probable cause. But they're basically finding, yeah, it's true or it isn't true, is basically their ruling.
Representative Walper?
Thank you, Mr. Chairman. Mr. Chairman, I think we have a problem here. And the problem is, in fact, in the statute. And I just want to read a couple sentences, which are these. After the filing of any complaint, one of the commissioners designated by the chair shall make, with the assistance of staff, prompt investigation in connection therewith. During the course of the investigation, the commission shall encourage the parties to resolve their differences through settlement negotiations. And if such commissioner shall determine that after such investigation that probable cause exists for crediting the allegations of the complainant, the commissioner shall immediately endeavor to eliminate the unlawful discriminatory practice And I will stop with that word. And what this is saying to me is what did the reason we're getting the kinds of reports that were mentioned here, which Executive Director Malachi says is not what we're doing now, is because that's what the statute calls for. This is in fact, if after such investigation, the finding of probable cause exists, the commissioner shall immediately endeavor to eliminate the unlawful discriminatory practice.
You know where that is?
It's in RSA 354A:21, Roman 2A. And if you have the same copy I do, it's about the 5th line down, begins with the word determined. But that whole thing that I started is 354 Roman 2A. After filing complaints, it's all one sentence. And the commissioner is already immediately to endeavor to eliminate the unlawful discriminatory practice, however. And that's as far as it goes. That's the whole investigatory part of this statute.
Representative Smith?
Sense of what goes on is that there are, in effect, two processes. One, going through the investigative stage, determining probable cause, and then going through a whole other procedure for a commissioner. And the problem, and then to take steps necessary, which would have required a decision that, yes, there's a problem here and we're going to try to resolve it. There doesn't seem to me to be any relationship between that language and what in fact happens.
Well, and that could be right, because it seems to me this just says they come in and file a complaint and have an investigation, and whatever is decided, and I totally agree with a report that is equivalent of summary judgment or as, and this is talking about one commissioner. There's no such thing as a hearing before the whole commission here. There just isn't any. Right? The co- Right, so it's totally understandable to me that the investigators would be doing all the work to make a case and getting it rubber stamped by the commissioner. Because that's what this statute says. Right, the only thing, there's no hearing in there. There is no hearing. No, there is a thing that says upon all,
That's not something though, because that's in statute, that's not something.
in case, if you go to B,
We can clean up statute.
that was A.
We can clean up statute.
That's A.
Yeah.
Okay, if you go to B, in case of failure to eliminate an unlawful discriminatory practice, commissioner shall issue a written notice, blah, 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 answer charges to 3 members of the commission, and then you have a hearing. But this statute says you do an investigation, and the commissioner, a commissioner, makes a determination and is immediately, what's that word I used? Immediately endeavor to eliminate the unlawful practice. And that's where this is breaking down. Huh? Well, But think about it, the intent is not that somebody comes in, makes a complaint, there's an investigation, there's a finding of probable cause, and then there's a hearing. No, that is not what this says. It says they make a complaint, there's an investigation. And if there's probable cause, the commissioner shall immediately endeavor to eliminate the unlawful practice.
So if we,
And
sorry,
if that fails, then there's another opportunity for a hearing before the whole commission. There's no time. I don't see it.
no, that's, that was 2 years.
So maybe they're thinking that,
Oh, yeah, at the end of that section. So,
any complaint filed pursuant
says,
can be removed after 180 days. Oh, 4, yeah.
yeah, in administrative section, the commission shall be exempt from the position, but shall close each case or commence adjudicative proceedings on such case under RSA 354 within 24 months.
Shall close or commence adjudicated
But
proceedings.
if with, so if we were to look at some of the language you were talking about with respect to probable cause, Representative Gordon, that would, based on Representative Wolper's comment, create a conflict right there in the statute. Change the statute. So you have to get into, so I'll just, pool the committee. Do we think that we really want to get into, that's a lot of stuff to get into. Do we want to be getting into that? I think we have to really look at that. Sure.
Mr. Chair.
Yes, Representative
Yeah, I'm
Lorenzo.
thinking, I'm just listening to what you're saying and you thought, well, do we want to get into that? We talked about a possible performance audit. So
Yep.
wouldn't it make sense to, if in fact there is going to be a performance audit, to write any statute after that?
I mean, I think there are some simple things, that we can do, but I agree with you. Getting into some heavy meat and potatoes like this, it's going to require some thought, some interactive dialogue, to just go in and, while I understand and respect your comments, it's going to take some thinking. And, so even though the performance audit, if we're lucky enough to get it, there's a length to that. I think the end product would be better than if just the folks on this subcommittee were to go into it. That's my thought.
I concur, because the more I think about this, the more I think this is meant to be a non-judicial procedure where there's just an investigation, and if there's reason to believe that the discrimination has actually occurred, reason to believe, probable cause, then there's effort to mitigate the circumstances, to remove the discriminatory practice, or correct whichever is, and only after that fails. But see, we're not getting to that point at all until we go through this very whole long thing and look for hearings, and then and that's why we have to go about removal, right? Because at the point in the statute where probable cause is determined, the commission is supposed to be taking action immediately, right? So allowing removal at that point is to totally thwart the role of the commission.
And I think that part we're all okay on. But I think, in light of that, I would even leave the probable cause language alone at this point. I think, broadly speaking, it's adequate. Maybe we can talk about how it's applied. But I just don't want to create conflict within the statute that we really haven't taken the time to look into. But on to Representative Smith's other point, which is gel car. So I just want to follow up on Representative Wolper's comment a little bit about maybe writing that into the statute, that we would, ask for a commission or a formal convening of GELCAR to do that. I understand your comment. Is that really necessary? But I think having something that kind of forces the hand would be good. Thoughts? Should we be putting that into the language of the of whatever we come out of here with? Yes, no? Well,
I don't think that's the way to handle that. I think the way to handle it is in the report that we make, as to the bill. I mean, and that would then be on record, and we then are free to, for someone to talk to the governor about the funding, and we're also free for someone to talk to the newly formed GELCAR to say, this is something that needs to be done, and we have it in, and we say, here's the report, and we're showing you that. I don't think that belongs in legislation.
Representative Wolpert?
I agree with Representative Smith. If we write a report along the lines that we just delineated, right, that we think we should do the removal from 296, but we really think what needs to happen is the rules need to be updated, then everybody in the world, including Director Malachi, can take that and use it as a hammer.
So rather than put that in the legislation, just put it in the final report and have them run with it. Okay, so Representative Smith, you also talked about funding. Are there thoughts from anybody about requests for funding in the report or comments? I know that the,
No place for, except in the report, we can acknowledge that we do not believe there's adequate staffing.
okay,
But other than that, or we could say in the report that based on the information the director has given us, we support her request for additional funds. In order for the agency to be able to carry out its statutorily required role. And then meanwhile, we need, have you had your hearing yet before, House? This is on the governor's request? Budget? Yeah. November. Okay.
so you think,
I think you could put in there that with in the current process, the resources are inadequate to meet reasonable timeframes for resolution of cases as required by statute, and that additional resources are required.
anybody else have any other thoughts? we'll give Representative Wolper a minute. Anybody else have any thoughts? You're very kind.
Yeah, so quick review. I have 5 items, maybe, could put R in here, maybe 4, to be included in our report. So, the inaction of SB 296 language, performance audit, the necessity to update the rules. And then you get to resources. What I had was resources above the normal operational level are required to address the backlog of cases. And current processes require additional resources to meet statutory requirements.
They don't create permanent positions or they don't add regular funding. We don't want them to think that they can do it once.
No, I agree. You want to bring some stability over to the commission. That's, I think, vital. And so it goes beyond the backlog.
Well, it does.
Yeah. But good.
To do is to prevent the agency from becoming a training agency, because from what Director Malachi said is that people come and they leave. They leave to go to, you know, more money or whatever, so. Yes, yeah.
Okay. So, I mean, those 4 items dovetail in with my thoughts. Everybody else agree? Okay, so what we'll do then is, I think from a statutory perspective, in terms of the bill, it's 296, we're good. The rest of it will go into the report. We'll work to get something together by the time that Representative Gordon convenes the committee as a whole, and we'll present that to the whole committee. So does anybody have any other thoughts? Representative Wolper?
So, Mr. Chairman, yeah, the concern, the only concern that I would have is if someone has to actually write the report, and typically that would go to all of us to review before it's submitted to the full committee. So I would suggest that we decide who's going to write it. That would be useful, right? And we plan to meet maybe just before the meeting for the whole committee to agree to it, because we can't discuss it any other way without having another meeting. Drafts can be distributed, yes.
Yeah, so once, I have to look at my calendar, and I'll get back to Representative Gordon on that, and then he'll kind of poll the rest of the committee, understand what their scheduling is like. We'll all get together. When we know that, we can kind of schedule something.
I said that as
Right.
October 19th.
In the afternoon? So when that comes out, we'll schedule something then to get the 5 of us together.
So, Mr. Chairman, I would suggest that we meet for lunch. No, we can't do it. It has to be a public meeting, right? Yeah. So, like half an hour before whatever the scheduled time for the regular full committee meeting is.
What's the date on that? 19th? All right.
Subject to your checking your calendar.
Subject to me checking my uh, I work for him, not the other way around, so.
Well, now
Um,
you're the chair of the committee.
all right. What about of the whole committee?
Yeah, sorry.
I'll give,
Yeah, you made it in the chair, Mark.
what's that? No, wrong answer. Okay, so that's fine. So, but in terms of, who is gonna write the report, I was thinking to be putting something together, unless you're volunteering.
I'm, I'm, I'm happy to let you have it.
All right. So, yeah, so I'll put something together. I've never written one before, but I'll figure it out. And then we'll get us all together and, I can, yeah, I definitely am going to be walking to the back of the room when this is done. Although she's grimacing a bit, so we'll see. Yeah, so,
If you could get the draft to us before the night before.
before the night before, I will do that. All right. Any other thoughts, questions? All right. Well, I want to thank everybody. This has been a lot. As Director Malachi says, a lot to unpack, and certainly a lot of learning for me. And everybody has been very patient with the process, and I've been very appreciative of that. And so we'll see everybody again at some point on the 19th.
Thank you, Mr. Chair, and thank you for all of your hard work. I'm very impressed.